Bombshell tonight, shocking new evidence emerges in Lindsay Clancy killing of her children.
Okay, so I am not going to let this go until someone is indicted, and it's not Lindsay. Okay, so I'm going to go through this rather fast. So 5:13 was the last time that her phone was unlocked. After that, it stayed locked forever. At 5:15, Patrick leaves the house. According to Patrick, she was in the living room with the baby. At 5:23:52, her Apple Watch recorded her heart rate at 57 beats per minute. That's important. At 5:33, Patrick calls Lindsay, and there's no answer. So at 5:33 was the first flight climb. If you don't know, when you have your iPhone or your watch, a flight climb is 10 steps up, not down. At 5:34, 1 minute later, Lindsay's phone calls Patrick's phone back. Okay, so if you have an iPhone, you have this feature. Return missed calls, allow access when phone is locked. So I tried this feature out. So the phone that I'm recording on, I called this phone, and then I handed this phone to my daughter, which it had a missed call on the screen, and I said, try to call that number back because it doesn't have her Face ID. He did it and it worked. So what I'm getting at is that it didn't necessarily have to be Lindsay that called him back. How is it that past phone records showed that she unlocked her phone numerous times, but this time she didn't? There's a lot of questions I have about Patrick, his testimony, his change of clothes, but I really think that there's someone else involved in this besides Patrick. So at 5:38 was the second flight climb. So if this was Lindsay, she only had from 5:15 to 5:33 when she did that first climb, she had 18 minutes to do what she did with the kids with a heart rate of 57 beats per minute. It's not making sense. So from 5:38 to 5:50, when the neighbor sees her outside, she had 12 minutes to go upstairs, move the bed, do what she did with the weapon, open the window, and go outside.
For some reason, the Daily Mail is now reporting, as you mentioned, that he wants to get married. The reporter Steve Helling, by the way, who's previously shared with us, he's spoken with numerous women who have corresponded with Watts, and he tells them he's accepted Jesus Christ as his Savior, yet he exchanges sexual messages with them. He makes promises about getting out and being together. And now we have Lizzie Henderson, who's gone so far as to starting, even before they have approval, Dave, to get married, they have to get approval from the Department of Corrections, I guess, that she's already using his name. She's wearing wedding rings, and they've been seen, I hate to say this, they've been seen making out when they have contact visits with each other.
I didn't know that conjugal visits were really a thing.
It wasn't conjugal, it's contact. Apparently, they get to have 10 seconds of hugging or whatever before the end of a contact visit. There's no reporting that we're aware of on conjugal visits, but they're definitely allowed to swap the spit and make out.
You know, his psychological evaluation came out. This is something that he is revealing. A lot of these documents are being unsealed. I'd really like to see the nitty gritty of this. I'd really like to see the notes. We'll probably never get that because it's protected under HIPAA or whatever. But he's talking about it because he's wanting to get out of prison. And he listed this on some prison documents. And he's saying that basically his conviction was unfair, that he falsely confessed. He was coerced by his defense team into confessing falsely. And he's revealing basically these mental health diagnoses that he received back in February of 2025 as his lawyers were preparing for trial. And, they weren't, Joe, you know how it goes. They weren't going to say, he's not guilty because of X, Y, and Z, because he has ADHD and OCD and, alphabet soup, this and that and the other. But they were going to use these to explain potentially his lack of affect, his lack of emotion when you see gory, grisly crime scene photos, and possibly as mitigation at sentencing had he been convicted at trial.
There is a lot going on at the same time in three cases. Three pieces of evidence that were never supposed to reach the public. A watch that recorded a heart rate of 57 beats per minute in the final minutes before a family's life changed forever. Then, nothing. No more data. No explanation. Just silence, sitting inside a piece of technology that had no idea what it was witnessing. A file, sealed for over a year, opened this month, revealing what one specialist wrote about a man already serving a life sentence. 6 sessions, 3 months, and a single observation that's now reshaping his entire legal fight in ways almost no one saw coming. And a man who lost everything that mattered to him 8 years ago through choices only he made, now applying to remarry. Tonight, you'll learn he's not the only person who's tried to reach him from the outside, and what that says about the strange, uncomfortable space where public fascination and private correspondence collide. These aren't closed cases sitting quietly in an archive somewhere, gathering dust the way old headlines usually do. These are active courtrooms, ongoing legal filings, and decisions being made this very week. Decisions that could shift 3 outcomes the public already thought they understood. Built on evidence none of it was ever meant to be part of. Let's begin. Subscribe now and let us know in the comments where you're watching from tonight, because these stories are unfolding in courtrooms most of you have never set foot in, but they're reaching living rooms all over the world. It begins with a date that's been repeated so often in courtrooms and headlines that it's become shorthand for tragedy. January 24th, 2023. Lindsay Clancy was, by every account before that day, an ordinary working mother, a labor and delivery nurse, someone who spent her career helping other families welcome new life into the world, who stood beside strangers in the most frightening and joyful moments of their lives and helped them through it. She had 3 children of her own, and by the end of that January afternoon, her family was never the same. For nearly 2 years, the public knew only the outline of what happened. What they didn't know, what no one outside a courtroom knew, was what a small device on her wrist had quietly recorded in the minutes before everything changed. A device most of us wear without a second thought. A device that has no understanding of grief or fear or the weight of a single afternoon. It simply counts. It simply records. And in this case, what it recorded and what it stopped recording became one of the most debated pieces of evidence in a modern American courtroom. That evidence came from a man named Ian Whiffen, a digital forensic specialist called to testify by the prosecution. His job wasn't to speculate about motive or state of mind. His job was to read data. Timestamps, signals, the small digital footprints most people never think about leaving behind. He has likely testified in dozens of cases before this one, but few of them carried the emotional weight this one did, playing out in front of a courtroom filled with people who had followed every detail of this family's story for years. At 5:23 in the afternoon, Lindsay Clancy's Apple Watch recorded her heart rate, 57 beats per minute. For context, a normal resting heart rate for most adults sits somewhere between 60 and 100. 57 is low. Not dangerously low, but low enough that, paired with everything else happening that day, it raised a question that still hasn't been fully answered, and may never be answered with total certainty. Because after that single reading, nothing. No further heart rate data. The watch simply stopped recording. Try to imagine sitting in that courtroom, hearing an expert describe a number like that. A heartbeat, slowed and steady, captured in a moment that would soon become unbearable to think about. For the families who have followed this case since it first made headlines, that single number has become almost impossible to separate from everything that came after it. It sits there, unresolved, a small mechanical fact refusing to explain itself. But the silence wasn't total. According to Whiffen's testimony, other data kept coming through even after the heart rate readings stopped. Movement data showed she climbed 2 flights of stairs, once around 5:03 and again around 5:33. Small, mechanical fragments of a much larger picture, recorded by a device that had no way of understanding what it was witnessing, no way of knowing that decades from now, people would still be trying to piece together what those numbers meant. Prosecutors have used this data to build a timeline, placing the events of that evening somewhere between 5:23 and 5:38. But here's what the numbers cannot tell anyone, not even the expert who presented them, why the heart rate recording stopped when it did. A watch can lose contact with skin. It can be removed. Its connection can simply drop. Whiffen himself acknowledged under cross-examination that the absence of a reading doesn't confirm what was or wasn't happening in that window. It only confirms silence. And silence in a court of law is not the same thing as proof. It's simply the absence of an answer, sitting where a certainty should be. Phone records added another layer entirely, another thread in an already tangled timeline. Clancy's phone was last unlocked at 5:13 that afternoon. At 5:33, an unanswered call came in from her husband Patrick, a call that would go unreturned in the moment, ringing into a house that had already begun to change. A few minutes later, a short outbound call, just 14 seconds, went back to him, one that may have taken place while the phone itself was locked. A second call from Patrick went unanswered at 6:09. Somewhere inside that stretch of minutes and missed calls sits the answer to what happened that evening. The technology recorded fragments. It did not record certainty. And for a family trying to understand how an ordinary afternoon became the center of a national conversation, that absence of certainty has been one of the hardest parts to sit with. Before we go further into what investigators found next, quickly, if you're finding this case as layered as we are, take a second to subscribe. There's a lot more still ahead, and you won't want to miss where this leads. Then came the search history, and with it, one of the most misunderstood pieces of evidence in the entire case. In the days leading up to that afternoon, searches were made from devices connected to the household. Some were unremarkable, the kind of searches any parent might make on an ordinary week. A search for a children's medication, a search for a nearby pharmacy. Others pointed toward a much heavier subject, searches related to mental health treatment, and searches touching on sensitive personal safety topics that investigators flagged as significant to the case. Online, that last detail spread fast, framed in countless posts and videos as if Lindsay had been independently and deliberately researching how to harm herself or her children. It became one of the defining pieces of misinformation surrounding this trial, repeated so often that many people online now accept it as simple fact. But testimony painted a far more complicated picture than what circulated on social media. The searches in question were not isolated queries typed one after another. They were part of what's known as a hyperlink chain, one search leading to a linked article, which led to another link and another, the way anyone might click from one page to the next without ever typing a new search themselves. Investigators traced the origin of that particular chain back to a search about a public figure whose death, years earlier, had made national news. A search that then branched, page by page, click by click, into a string of loosely related content. It is a very different picture than the one so many people believed after the news first broke, and it's a distinction the defense fought hard to make clear in front of the jury, because the difference between a deliberate search and a chain of unrelated clicks may be one of the most important details in this entire case. Alongside the digital evidence, jurors heard something far more personal, journal entries written in Lindsay's own hand in the weeks and months before that January afternoon. These weren't polished statements meant for anyone else to read. They were private, unfiltered, the kind of writing a person does only when they believe no one else will ever see it. She wrote about struggling to feel connected to her youngest child, about guilt, about feeling like she was failing the two children she'd already been raising for years, even as she desperately wanted to be present for all three. She wrote, in her own words, about wanting more than anything to feel like a good mother, and about feeling that version of herself slipping further away with each passing week, no matter how hard she tried to hold on to it. Reading those words now, knowing what would eventually happen, is one of the more difficult parts of this case to absorb. They read like the private thoughts of someone in genuine distress, someone reaching for something that kept slipping just out of reach. Her mother took the stand as well, describing text messages in which Lindsay wrote that something wasn't right, that she needed her mother to come, that she was struggling in a way she couldn't fully put into words. Her mother described a conversation that took place in the kitchen, one that included an admission most parents could never imagine hearing from their own child. It was, by every account given in court, a warning sign that something was deeply wrong, a warning that, in hindsight, arrived far too late to change what followed. There is something particularly heartbreaking about a mother testifying against the backdrop of her own daughter's unraveling, trying to explain, under oath, the moment she first sensed that something in her child's world had shifted. None of this, according to Lindsay's defense attorney, Kevin Reddington, is being presented to argue that his client is innocent of what happened that day. That distinction matters because it's one that's been widely misreported and misunderstood outside the courtroom. Reddington has never claimed Lindsay didn't do this. What he has argued, consistently, from opening statements through the presentation of the defense's case, is that she should be found not guilty by reason of a severe mental health crisis. Specifically, postpartum psychosis, a rare but recognized condition that can fundamentally alter a person's grip on reality in the weeks following childbirth. A condition that medical professionals describe as capable of separating a person almost entirely from the version of themselves everyone around them knows. Early in the defense's case, Reddington asked the court to rule that prosecutors had failed to meet their burden of proof. Not that the events of that day didn't occur, but that the state of mind required under the law for a guilty verdict on the most serious charges had not been established by what the state presented. The judge declined to rule in the defense's favor on that motion, and the trial continued into its next phase. But the confusion that followed online, some outlets and social media users describing it as a bid for a mistrial or even a claim of outright innocence, says something about how difficult this case has been for the public to fully understand. This isn't a case built around the question of who did it. It's a case built around a far harder question. What was happening inside someone's mind? In the exact minutes, a piece of technology simply stopped recording. And that's where this case still stands, as testimony continues to unfold. A 10-minute gap in a digital timeline. A watch that stopped listening at the exact moment the world needed it to keep talking. Prosecutors say the silence points to one conclusion. The defense says that same silence proves nothing at all. 12 jurors are now the only people tasked with deciding which interpretation is correct, carrying the weight of a decision that will define how this story is remembered for years to come. Until they reach that decision, the gap remains exactly what it has always been since the moment Ian Whiffen first read it aloud in a Massachusetts courtroom. Unanswered. That gap in the data is one kind of unanswered question. What we found next is different, because the report that answers it was never supposed to leave a locked file. Every case carries a moment when the public record and the private record collide, when something written for a courtroom's eyes only ends up in front of millions. For Bryan Kohberger, that moment arrived this month, when a sealed evaluation, more than a year old, was finally unsealed. To understand why this document matters, you first have to understand where this case actually stands, because much of what circulated online after the unsealing misrepresented the stakes entirely. In July of 2025, Kohberger pleaded guilty to the murders of 4 University of Idaho students, Madison Mogen, Kaylee Goncalves, Xana Kernodle, and Ethan Chapin. 4 young people, each with a life ahead of them that ended in November of 2022, in a case that captivated the country for years before it ever reached a plea deal. That plea, negotiated between his defense team and prosecutors, accomplished something specific and significant. It removed the death penalty from consideration. In exchange for his admission of guilt, Kohberger was sentenced to 4 consecutive life terms without the possibility of parole. No jury trial, no death penalty, a resolution of a kind that many families involved in this case still describe as deeply unsatisfying, even as it brought a form of legal closure. That single fact, that the death penalty was already off the table by the time he entered his plea, is essential to understanding everything that follows. Because the evaluation now making headlines wasn't created to save him from execution. It was created for an entirely different reason, one far more procedural and far less dramatic than the way it's often being described online. Before Kohberger's plea, while his defense team and the prosecution were still negotiating the terms of any potential agreement, his attorneys commissioned a neuropsychological evaluation, not to argue that he was unfit to stand trial, not to pursue an insanity defense. The purpose was narrower and more technical than that, to determine whether Kohberger's mental health history and developmental background should factor into sentencing considerations as a mitigating circumstance, something that might be weighed in his favor, rather than an aggravating one, something that might be weighed against him. It's a distinction that matters enormously in the legal world, even if it rarely makes for a compelling headline. And it's a distinction that appears to have been lost in nearly every piece of coverage that followed the evaluation's release. The specialist brought in to conduct that evaluation was Dr. Rachel Lawson-Orr, a licensed neuropsychologist retained by Kohberger's defense team. Over the course of roughly 3 months, spanning 6 separate sessions, she met with Kohberger repeatedly, conducting the kind of extensive testing and clinical interviewing that goes into building a comprehensive psychological profile. It is not a quick process. It is not a superficial one. It involves hours of structured testing, careful observation, and a level of clinical documentation most people will never encounter in their own lives. What she recorded in clinical and measured language offers a rare and unusually detailed look into how Kohberger presented across those sessions. She noted early on what she described as a restricted range of facial expression, a kind of consistent stillness in his features that she characterized as a stoic baseline affect. She observed that his smiling in social contexts was inconsistent, sometimes entirely absent, and that certain small physical behaviors, gestures, tone, the rhythm of conversation struck her as atypical in ways that aligned with a broader pattern she was beginning to identify. Over the course of those 6 sessions, Dr. Orr ultimately diagnosed Kohberger with 4 current conditions: Level 1 autism spectrum disorder, obsessive compulsive disorder, attention deficit hyperactivity disorder, and a restrictive eating disorder known as ARFID, which stands for Avoidant Restrictive Food Intake Disorder. The evaluation also noted 4 additional diagnoses tied to his past, conditions he had met criteria for at earlier points in his life, but that were no longer considered active: developmental coordination disorder, an unspecified depressive disorder, anorexia nervosa, and opioid use disorder, connected to a period of substance dependency in his teenage years that the evaluation described as being in sustained remission. Reading through a document like this, it's worth pausing on what it actually represents. It isn't a portrait of a man captured in the moment of his crimes. It's a clinical snapshot, taken years later, filtered through the careful and deliberately neutral language of a licensed professional whose job was to document, not to explain away, not to excuse, simply to document. There's something almost unsettling about the contrast between the clinical detachment of a report like this and the enormity of what it's ultimately attached to, a reminder that legal and psychological processes often move at a pace and in a language entirely separate from public grief. For over a year, this document sat behind a seal, viewed only by the small circle of people directly involved in the case. It wasn't written with an audience in mind. It was written for a courtroom file, for attorneys weighing strategy, for a process that, at the time, seemed to be moving toward a relatively contained conclusion. That containment didn't hold. Because in the time since Kohberger's guilty plea, something changed. Kohberger, through a newly filed petition, has moved to withdraw that plea entirely. In his filing, he alleges that he received ineffective assistance from his defense counsel, that he was, in his words, convinced to falsely confess, and that promises made to him during the plea process were not honored. This is not a minor procedural footnote. It is a direct attempt to undo the resolution that brought this case, for many people, its only sense of closure. And here is where the stakes of this case take a sharp and consequential turn, one that reframes everything discussed so far. If Kohberger succeeds in withdrawing his guilty plea, his conviction would be vacated entirely, and the case would return to where it stood before that plea was ever entered. which means prosecutors would once again be free to pursue the death penalty, the very outcome his original plea deal was specifically designed to avoid. Legal experts who have reviewed the filing describe the path forward as an uphill one. Petitions like this typically require Kohberger to prove not just that his attorneys made mistakes, but that those mistakes directly rendered his guilty plea involuntary, a high bar that most petitions of this kind fail to clear. The process is expected to take months, working through hearings and legal arguments before any resolution is reached. The families of the victims have not stayed silent through any of this. In a public statement following news of the petition, the Goncalves family described their confidence that, should this process move forward, Kohberger will ultimately face the sentence he avoided the first time, adding that they welcome the opportunity for a trial they were denied when he entered his plea. Which brings us back to the evaluation itself, and the strange, almost ironic timing of its release. A document built, in its original purpose, to soften a legal outcome that had already been secured, has resurfaced at the precise moment when that outcome is most at risk of being reversed entirely. A report meant to argue for mitigation is now circulating in the public conversation, just as the death penalty, once removed from this case, has become a very real possibility again. Nothing about this evaluation changes what happened in November of 2022. It offers no new account of that night, no reconsideration of guilt or innocence. What it offers instead is a clinical window into the man at the center of one of the most closely watched cases in recent American history, unsealed not because anyone chose to release it, but because the legal process surrounding his case is, once again, wide open. That's one report never meant for public eyes, now shaping the future of a case many believed was already settled. Our third story tonight is different, because this isn't about a document written by a specialist. This is about words a man chose to write himself, and the audience he never expected them to reach. Before we move into that final story, if this kind of detail, the small, overlooked pieces of evidence that end up defining a case, is what keeps you coming back, make sure you're subscribed. This channel exists to cover exactly these details, and there's more of this coming soon. Some cases fade from public attention once a sentence is handed down. This one hasn't, and this month, it's back in the headlines for a reason almost no one saw coming. Chris Watts is currently serving multiple life sentences at Dodge Correctional Institution in Wisconsin, following his conviction for the 2018 murders of his pregnant wife, Shanann, and their two young daughters, Bella and Celeste. It remains one of the most widely covered domestic tragedy cases in recent American memory, a story that shocked the country not just because of what happened, but because of how ordinary the family had appeared right up until the moment everything fell apart. 8 years have passed since that conviction. And this month, reporting revealed something that, for many people following this case, felt almost impossible to process. Chris Watts has applied to marry again. The woman at the center of this new chapter is Lizzie Henderson, 39 years old, originally from Ohio, working as a licensed realtor before this relationship became public. According to multiple reports, Henderson and Watts met while he was already incarcerated, and over the past 15 months, their relationship has developed into something both of them now describe, through relatives, as serious and long-term. What makes this development particularly striking isn't simply that the relationship exists. It's the extent to which Henderson has reshaped her own life around it. She relocated from Ohio to Wisconsin specifically to be closer to the facility where Watts is housed, a move her own family has confirmed. Over the course of their relationship, she has visited him 23 times, always through contact visits, rather than the brief, glass-separated meetings many people picture when they think of prison visitation. These visits, which can last up to several hours, allow for direct, face-to-face contact within the boundaries the facility permits. According to Henderson's relatives, both she and Watts have formally submitted a request to marry within the Wisconsin prison system, a process that requires approval from facility officials before any marriage can move forward. Court records confirm that Henderson filed for a confidential name change earlier this year, though the specific details of that filing remain sealed. Her own family members, however, have been far less guarded, confirming that she has already begun referring to herself, informally, as Lizzie Watts, both within their family and in her personal life. She has also been photographed wearing rings on her left hand, a detail that, combined with everything else, strongly suggests both parties consider this relationship to be heading toward marriage, regardless of the formal paperwork still pending. When asked directly about the nature of her relationship with a man convicted of killing his own family, Henderson has not shied away from the question, though her answers have done little to satisfy public curiosity. She has described the origins of their connection as something deeply personal, something she considers to be between herself, Watts, and her own faith. When pressed on how she reconciles her feelings for him with the details of his crimes, she offered only that he knows how she feels and that she wishes to be respectful of everyone involved, without elaborating further. It would be easy, at this point in the story, to treat Henderson as an isolated case, a singular and unusual example of someone drawn to a man serving multiple life sentences. But that framing misses something important, something that reporting has increasingly brought into focus over the past year. Henderson is not the only woman who has maintained a relationship with Chris Watts since his incarceration. According to multiple sources with knowledge of his correspondence, Watts has, over the years, exchanged letters with a number of different women, some of whom reached out to him independently after learning of his case. In at least one documented instance, reported extensively last year, Watts maintained a lengthy written correspondence with a woman identified only as Deborah, a relationship that, according to those letters, carried distinctly religious undertones. In his own words, written from prison, Watts described his incarceration as something close to a form of purpose, comparing his circumstances to religious suffering, and describing his correspondence as part of what he believed was a larger, divinely guided plan for his life. That particular relationship, according to reporting, eventually ended, with Watts writing that circumstances beyond either of their control meant they could not be together. This pattern of women reaching out, of correspondence developing into something more personal, of religious language woven throughout, is not unique to Chris Watts. It reflects a broader phenomenon that has drawn increasing attention in recent years, one connected to several of the country's most widely covered convicted killers. Men whose cases became the subject of national fascination sometimes find themselves receiving letters and eventually forming relationships with individuals who reach out from the outside, drawn by any number of complicated and deeply personal reasons. It's a phenomenon that researchers and criminologists have studied for decades, though it remains something the public largely finds difficult to fully understand. What makes Watts' situation different from many of these cases is how far it appears to be moving. A marriage application, submitted formally through official prison channels, represents a level of commitment well beyond an ongoing written correspondence. It signals an intention on the part of both individuals to build something that extends beyond the walls of a maximum security facility, something that, if approved, would carry legal and lasting weight. For now, that approval has not been granted. Under Wisconsin's Department of Corrections policies, individuals incarcerated within the state prison system are permitted to marry, but only under a formal review process, one that requires sign-off from facility leadership before any ceremony can move forward. That process is currently underway, and no timeline has been publicly confirmed for when or if a final decision will be reached. Which leaves this story exactly where it stands right now. A marriage neither confirmed nor denied, a relationship built almost entirely through visitation rooms and written correspondence, and a woman who has reshaped her entire life around a man the country has spent 8 years trying to understand. Whether that request is approved remains an open question. What isn't in question is how much attention this development has already drawn, reigniting interest in a case many assumed had already reached its final chapter. 3 stories, 3 completely different courtrooms, 3 different years, 3 lives that had nothing to do with one another, and yet, sitting underneath each of them, the same quiet detail keeps surfacing. A watch that kept measuring long after anyone thought to ask it to. A file built for one narrow legal purpose, now read by people it was never written for. Words put down on paper by a man who believed, at the time he wrote them, that no one beyond a handful of recipients would ever see them. None of it was built for an audience. A wristwatch doesn't know it's collecting evidence. A clinical evaluation, commissioned quietly by a defense team, isn't written with the expectation that strangers will one day read it line by line. A letter sent from behind prison walls isn't drafted with a headline in mind. In every one of tonight's cases, something small and private was created for a single, specific purpose. And in every one of tonight's cases, that purpose was quietly overridden. What was meant to stay contained didn't stay contained, and all 3 found their way in front of an audience anyway. That alone would be worth noting. But what makes it worth sitting with a little longer is what's happening now, on the other side of that exposure. Because in each case, the information that was never meant to reach the public isn't just sitting there as a footnote. It's actively shaping outcomes that no one, not the people who created the data, not the people who wrote the file, not the people who sent the letters, could have predicted when they first put pen to paper or strapped a watch to a wrist. A 10-minute gap in a digital timeline is now one of the central questions a jury has to resolve, in a case where the difference between 2 verdicts may come down to what a piece of consumer technology did or didn't manage to record. A sealed evaluation, originally built to soften a legal outcome, has resurfaced at the exact moment a separate legal filing threatens to bring back a sentencing outcome that had already, once, been taken off the table. And a private correspondence, carried out for years without public knowledge, has become part of the reason the public is now watching to see whether prison officials will approve a marriage that, until recently, almost no one outside a small circle knew was even being discussed. None of these 3 outcomes are settled. That's worth being clear about. The jury in Massachusetts hasn't reached a verdict. The legal process tied to the second case is still unfolding, with hearings and rulings still ahead. And in the third case, no formal decision has been made about whether that marriage will be allowed to proceed at all. Every one of tonight's stories is, right now, still being written, which means everything said here tonight is a snapshot of where things stand, not where they'll end. But it's worth asking the question anyway, even without an answer waiting on the other side of it. What changes now that the parts no one meant for us to see have already been seen? A heart rate reading that stopped mid-recording, an evaluation written for a courtroom file never meant to become a headline, a pattern of correspondence sent quietly over years to more than one recipient. None of it was supposed to end up here. All of it did. And now that it has, it's not sitting quietly in an evidence locker or a sealed folder somewhere. It's actively influencing what happens next, in real time, in front of everyone. That's where we leave things tonight, not with conclusions, because none of these cases have reached one yet, but with a clearer picture of exactly how much is still unresolved, and exactly how much is riding on details that were never supposed to leave the rooms they were created in. If tonight's report left you with more questions than answers, that's exactly where we'll pick things back up. There's another case already waiting for its own turn, with its own piece of evidence that was never meant to surface, and its own outcome that's still very much undecided. Subscribe now so you don't miss it when it comes, and drop a comment letting us know which of tonight's 3 cases you'll be following most closely. Until then, take care of yourselves, and we'll see you in the next one.